Good afternoon, everybody, and welcome to the very first virtual Moos Family Speaker event. My name is Valerie Forbes, and I am the Dean of the College of Biological Sciences at the University of Minnesota. I'm also a member of the Board of Directors of the Freshwater Society. As most of you know, Freshwater is a member-supported nonprofit founded in 1968, working to inspire and empower people to value and preserve our freshwater resources. Freshwater has partnered with CBS since 2010 on this free speaker series, but the connection between Freshwater and CBS goes way, way back, as the founding dean of CBS, Dick Caldecott, together with his very good friend, Dick Gray, were instrumental in starting Freshwater all these years ago. In these uncertain times, there's one thing we know for sure. We could not survive without water, clean, fresh water. The Freshwater Society needs your support. So I encourage you to visit freshwater.org and donate and or become a member of this worthy organization. So in today's virtual Moos, we're experimenting with a slightly different format that we're hoping will work better with the shorter program and the online technology. So first I have a couple of housekeeping items. Those of you attending from our audience can enter questions using the chat function in Zoom at the bottom of your screen at any time during our discussion. And we're collecting these questions and we'll address them in the second part of the program. And the panel will talk about those toward the end. If you're on Facebook, you can also post questions that we'll collect and answer as well. Those of you who may be wondering, we're going to be recording this event and it will be available on Freshwater's website. All right, we are ready. So it is my pleasure to introduce our speakers for today. First, Robin Greenwald, Esquire, is head of the Weitz and Luxenberg Environmental Toxic Torts and Consumer Protection Litigation Group. She's a renowned environmental and consumer class action attorney who takes the side of the taxpayer and citizen. She's a former assistant United States attorney and assistant chief of the U.S. Department of Justice's Environmental Crime Section. Her recent successes include the class action settlement surrounding the 2010 British Petroleum oil spill in the Gulf of Mexico that secured full compensation for hundreds of thousands of innocent victims of the spill. Today, she'll discuss her work in Minnesota to hold the companies that refine coal tar sealants accountable for the cleanup costs of their stormwater ponds. The burden to clean up was either going to be on the taxpayer or on the polluter. Next, Randy Neprash is a stormwater regulatory specialist with the Santec Consulting and Minnesota City Stormwater Coalition. Formerly a construction company owner and carpenter for 18 years, he is now a civil engineer specializing in stormwater. Randy has worked under contract for the Minnesota City Stormwater Coalition for 12 years. This is an organization of approximately 130 cities regulated under the MS4 Stormwater Permitting Program. He has advised many public and private agencies on issues related to TMDL, that's total maximum daily load, implementation plans, low impact development, and alternative stormwater management. Randy was named the Professional Manager of the Year in 2014 for water resources by the American Public Works Association. And finally, Dr. Matt Simsek is an associate professor at the University of Minnesota Department of Environmental Health Sciences. His research broadly focuses on how and why organic pollutants end up in our atmosphere and water. He was a chemistry major at Michigan State University, received his master's in civil engineering from the University of Minnesota, and a PhD in environmental science from Rutgers University. He's been affiliated with the Division of Environmental and Occupational Health School of Public Health at the U of M since 1999. Okay, so rather than starting as we normally do in our Moos series with a general talk followed by the panel debate, we're going to start by introducing the audience to the topic in a general way and have the panelists sort of flip back and forth and then we'll end with a presentation by Robin. So let's start with the basics, and I'll start with Matt. What exactly are PAHs?
So the PAHs, I can actually share my screen here, and I've got a couple of quick slides to show. Make sure I do this correctly. There we go. So PAHs are just an acronym for polycyclic aromatic hydrocarbons, and these are compounds that, as the name implies, aromatic. So you have benzene rings. You have anywhere from 2 rings to more, and the examples I give here are the smallest one with 2 rings is naphthalene, and then on up through things like phenanthrene, and all the way up to these big ones like coronene. And they are products of incomplete combustion. So anytime you have anything biological, you have big biological molecules, and you burn that, and you don't do it efficiently enough to send it all the way to carbon dioxide and water, which is almost always, these molecules will rearrange themselves, and the most stable way is to form these aromatic rings and these compounds with multiple aromatic rings. Because they're from biological molecules, the other way we transform biological molecules, well, not we, the other way biological molecules are transformed is through burial and down into the crust. And so you take large biological molecules, you put them under high temperature and pressure, you can also form these PAHs, and so PAHs are also found in uncombusted petroleum. So the 2 major sources of PAHs to the atmosphere are incomplete combustion and uncombusted petroleum. These molecules here, what I've shown are what we call parent PAHs. These are only carbon and hydrogen. We can actually have alkylated PAHs, so there would be functional groups and long chains coming off of these aromatic rings, and we can have substitutions. We can have nitrogen compounds in there. We can even have nitroaromatics, where we have nitro groups attached to the rings. And so it turns out that in uncombusted petroleum, we have a higher degree of those alkylated and nitro species than we would in from incomplete combustion. So because though PAHs are a product of combustion, they've basically, well, number one, they're ubiquitous. We find them everywhere. And 2, they've been around since the advent of fire. So we've had to deal with PAHs forever. Unfortunately, when we add more PAHs to the mix, it can overwhelm the system. And so in a combustion situation, when we burn these big molecules, create PAHs, they can be present in the atmosphere in both the gas and particle phases. And because of that, they can undergo long-range transport, which lends to their ubiquity. Why do we find them all over the globe? While they're in the atmosphere, they can also react, and that's when you'll form these nitroaromatics and different things in the atmosphere. Those particles can then deposit out of the atmosphere and fall into our surfaces, lakes, rivers, soils, forest canopies, things like that. The gas phase can undergo air-water exchange, air-plant exchange, things like that. When we look at the other side, the non-combustion source of PAHs, the uncombusted petroleum, we find those things in like tire wear, on our roads, any surfaces we apply to the roads, be it asphalt or coal tar sealants. There were a few roads in Minnesota that were actually coal tar based, not many. But the other place where you'll see as leads into this session is coal tar sealants on parking lots, basically to allow or to prevent water from percolating through a parking lot surface, which can then freeze and thaw and cause degradation of the surface. The problem with PAHs is even though they've been around forever, they're toxic. They're carcinogenic. They can be directly carcinogenic through as a mutagen. And it turns out that the nitro PAHs and the alkylated PAHs, which again we find more of in uncombusted petroleum, tend to be more toxic than the parent PAHs themselves. The other thing that can occur for all PAHs and becomes especially important in aquatic systems is what we call photo-enhanced toxicity or photo-induced toxicity. So PAHs have all of those, a little chemistry background. You've got the big aromatic rings, you have all these pi electrons. Those can get excited very easily by the absorption of light. That energy has to go somewhere. That energy can actually create these reactive oxygen species that could then cause more damage. And we see this most frequently in shallow water systems like our stormwater ponds. You have, especially if you have things like larval fish that will tend to go towards the air-water interface of the water to avoid predation because the light bends, they can't be seen by predators as easily. So PAHs are, they've been with us forever, they're going to be with us forever, and they're toxic. And we have all these additional sources now, besides besides incomplete combustion in the form of uncombusted petroleum. And I will stop sharing.
All right, thank you. That's a very good introduction to PAHs and their fate in the environment. Let's switch over to Randy for a couple minutes. And I know he's got some slides that are going to be shared as well. So we'll let those pop up. So Randy, if I can follow along from Matt's nice introduction, how exactly do PAHs end up in pond sediment?
Thanks, Valerie. And thanks, Matt. That was a really nice introduction. I really appreciate the opportunity that Freshwater is providing here to talk about this topic. I should say that I am a civil engineer, which means that I am definitely not a scientist. I'm also not an attorney. I speak for a coalition of cities, but I definitely do not speak for our state regulatory agency, the Minnesota Pollution Control Agency. If you could change the slide, please. So Matt talked about PAHs being ubiquitous in the environment. We find them now at significant levels in stormwater ponds. And what we find is that most of them come from coal tar sealant. This is a graphic from research work done by Dr. Judy Crane, staff scientist at the Minnesota Pollution Control Agency, showing that the majority of PAHs in stormwater pond sediments are coming from coal tar sealant, and far more than any of these other numerous sources in the environment. Next slide, please. This pattern shows up not just in the work from the PCA, but also research work done by the Metropolitan Council, a regional planning entity here in the Twin Cities, and some really excellent research that's been done by Peter Van Meter and Barb Mahler with the US Geological Survey. Next slide, please. How it gets into the ponds is really pretty simple. The sealant is applied to asphalt pavement. It dries and cures and almost immediately starts to wear off. Part of the form of that wear is that it's transformed into small particles. And then when rain falls on the pavement, washes off, it ends up in our stormwater conveyance systems and receiving waters. Those include the constructed stormwater ponds that cities own and operate. So that's how the stuff gets there. Next slide, please. What happens in stormwater ponds is we collect the stormwater, we essentially make it stop. Sediment that was carried in the stormwater when it was moving settles out in the bottom of the ponds. Various pollutants are either attached to the dirt particles or are separate particles unto themselves. And so those pollutants end up in the stormwater pond sediments. This is very strong part of the water quality improvement function of these stormwater ponds. But as the sediment builds up over time, the wet volume of the pond is lost slowly but surely, and that water quality improvement function is diminished. For some ponds, this can take place pretty quickly. You'll have significant loss in 5 years, perhaps. In other ponds, it can take 20 years or more for this change to be noticeable. But cities are depending upon that water quality function, so that when the buildup is sufficient, the stormwater ponds really need to be dredged. What we're finding is that if the dredged sediment is found to be sufficiently contaminated with PAHs, instead of being able to use it as fill for, say, a construction project somewhere nearby, the contaminated sediment has to be trucked quite a distance away to a lined landfill, which adds an enormous extra cost to these dredging projects that cities do. Next slide, please. So how big a problem is this for the cities that own and operate constructed stormwater ponds? The sad truth is we really don't have a good answer to this. For the last several years, I've relied on a draft document from the PCA that dates back to 2011, but we've recently found significant errors in that document, so it can't be relied on now. It's worth noting, though, that the MS4 permitted cities in Minnesota under the permit counted their constructed stormwater ponds. And we found that about 170 cities or so have approximately 14,000 constructed stormwater ponds that they own and operate, otherwise known as a lot of ponds. We haven't tested very many of those ponds, but what we're finding when we test the sediments is sufficiently high pH contamination in the sediments in about 10 to 25% of the ponds to require this extra cost for trucking and landfill disposal. What that means, we've seen individual projects where a pond dredging project for a relatively small residential constructed stormwater pond that would have cost about $20,000. When you add the trucking and landfill cost, it turns into something like a $250,000 project. So you can do what I refer to as courageous multiplication. So let's say that about 2,000 of the ponds are contaminated. That's a little bit less than 15% of the ponds. And let's just say, give a conservative number, that there's extra cost of about $100,000 for each one of those pond dredging projects. When you multiply that, you come up with $200 million, otherwise known as a lot of money. It means that these costs are enormous for cities. We're talking easily in the hundreds of millions of dollars. The end result is that cities are holding off on dredging many of their ponds in the hopes that we can come up with a better solution than having to truck all this stuff off to landfills. Next slide, please. So now that we know that we have a significant problem, what have we done about it? One of the remarkable things that we've done in Minnesota is to adopt a statewide ban on the sale and use of coal tar sealant. To the best of my knowledge, we were the second state in the country to do that, and we're still only the third state in the country to have a statewide ban. We did it in 2013. It went into effect on January 1st, 2014, and it's really pretty simple. You can see the statutory language here. This addresses the problem moving forward. We won't have, or we'll have much less coal tar sealant coming into our ponds, but we still have a huge legacy problem all the PAHs from coal tar sealant that was applied before 2014 and the sealant that's in place now. Next slide, please. So one of the other questions for cities in searching for a solution was there any chance of seeking compensation to cover these immense costs that we're facing in the relatively near future? One way to look at this in relatively simple terms is that we appear to have a product that is responsible for most of the problem, coal tar sealant. That product, when used exactly as intended and exactly as directed by the people that sold and applied it, has caused significant environmental harm and will cause great cost for cities when their ponds need to be dredged. So the next logical thought was, should we look to the refiners of coal tar and coal tar sealant that turned their coal tar waste into a polluting product to recover costs? And this is the point where Robin and the attorneys come into the process. Thanks.
Thank you, Randy. Well, so that was great. Let me just recap. We know what PAHs are. We know how they get into the environment. We know that they're toxic and a problem. They're a very hugely expensive problem. Minnesota is a leader in dealing with these things moving forward, but we still have this major legacy problem, which seems to be largely attributed to one kind of particular product, which is the coal tar sealants. So who pays and what are the issues around that? And now I want to turn over to Robin to help talk about some of these complex issues. And you need to unmute yourself, Robin.
Did I share my screen properly?
Your screen is shared. It looks great.
Okay, let me go down now and do my, okay. I'm not good at technology, so I apologize to all of you if I am not too smooth at this. So thank you for having me come today. I want to start out by saying that I can't really talk about the Minnesota cases because they're in litigation, and it's just at a point of the litigation that it would be impossible for me to talk about them. So what I want to talk about today is more the concept of cost recovery action, and really talk about the model that sort of underlies the idea of who pays when municipalities are faced with pollution that was not at all their fault, and there was nothing they could do about it, but now are shouldering the cost. So I think this problem has already been addressed by Matt and Randy, so I don't think I have to go into certainly the first bullet point. But the real question is, should municipalities pay, in other words, taxpayers, or should the entity responsible for the pollution have to pay? And as you just said, Professor, if in fact it's the latter, how do you do that? Litigation is an option always. I mean, obviously, in the absence of litigation, cities can always do some type of outreach to polluters and say, you have caused us a lot of damage, and try to resolve things through some type of mediation, but historically that has not been overly successful. I don't know any example, as I sit here today, of a company saying, sure, I'll pay for that, but maybe there's one out there and I just don't know it. So anyway, where does that leave us? So obviously you can't have any type of, well, there are strict liability statutes, of course, but just from a pure negligence perspective, which is another cause of action one could always bring. In other words, you have a duty, and you breach that duty, and you breach that by not meeting a standard of care. And so the question becomes, did coal tar refiners even know that they had a problem with the coal tar pitch that they are selling to manufacturers to put in coal tar sealant? So the answer to that is yes. First of all, the coal tar pitch is a waste product of their coking operation. This is not but for them using it in coal tar or selling it for use in coal tar sealant, it would have to be a hazardous waste that they get rid of, and it will cost them a lot of money. So they fully well know that this is not a safe product. They know that they have high concentrations of PAHs, and they certainly know, everybody knows, that PAHs cause serious health and ecological damage. That's not a secret to anyone, particularly sophisticated companies like refiners. Coal tar refiners have known for decades that they were selling millions of pounds of this product. And so why do they have to sell so much? Because they know it degrades, right? So if you only need it once, then you wouldn't be selling it anymore. At some point in time, blacktops would be covered with coal tar sealant, roofs, whatever you're using. And if it didn't degrade, you wouldn't have to reapply it. But of course, they know it has to be reapplied. It's part of their system. And so they know that it degrades. And then, as both Matt and Randy already covered, when it degrades, where does it go? It has to go somewhere, and it ends up going into the environment. And then that costs cities money. So these are some of the costs that we understand from having spoken to cities over the course of the last 5 or 10 years, no, really 5 years on these issues, that cities can face, do face. And they are pretty straightforward. I think probably most of you listening today, these will be pretty apparent. Certainly some towns that have had to dredge materials, if you have a requirement to test the dredge spoils before you dispose of them, you had cost of testing. Because even if you have a pond that has PAHs, that doesn't mean all the sediment in the pond. It could be one part of a big pond has the PAHs and another part doesn't. So you have testing costs. And then there's past removal and disposing of PAH sediment. Then there's future costs of ponds that you might have to test in the future. And then, of course, when those are positive PAH results, the future cost of removing. And then, you know, we don't really know yet about PAH contamination in groundwater. That really hasn't been developed. My suspicion is at some point in time, we are going to find out that there are PAHs in groundwater. That's going to end up in drinking water supplies, and cities may have to face that as well. But I know that's not the subject of today's talk, but I think cities should be aware of that as a potential problem down the road. So I want to talk about other litigation because this is the same model. It doesn't matter. So there is a long history, I'd say 15 years or more, in jurisprudence around the country of what I'm going to simply call cost recovery action. And it is as simple as you put a product into the marketplace. That product caused contamination of our environment. We now have that contamination of the environment has now impacted something that we have to pay money for to get rid of, whether it's drinking water, and you'll see most of these have been groundwater contamination. But the theory shouldn't be different. So we now have to spend money to get this chemical out of our drinking water supply before I serve it to our customers. And most water providers are municipal water providers. And so this has been something that has been litigated many times. And so these were some examples. The MTBE is what I'm going to talk about in more detail today. Right now, ongoing all around the country, which I'm sure you've all heard about, is PFOA. Probably many of you on this call today are dealing with PFOA in your municipality. Again, this was a Minnesota issue because 3M that made PFOA initially made it in Minnesota. And so contaminated quite a bit of the groundwater there, and there was litigation on that. I did not participate in that, but I am involved in PFOA litigation in various parts of the country, and it's the same concept. These manufacturers, 3M and DuPont, made a product that they knew was going to contaminate groundwater because they're used in various manufacturing processes. And they, in the course of that, they discharge the waste. The waste has PFOA, and PFOA lasts forever. I mean, there's some estimates that it lasts like, I don't know, thousands of years. I don't think you could ever bring a lawsuit for thousands of years of damages, but the bottom line is it's not going away. And if it's in your water supply, it's a problem, and it causes illness, right? So there was a panel of scientists in Parkersburg, West Virginia, a case that was pending in Ohio, and the court, after many years of litigation, 10 years, said, I need to get to the bottom of this. I need to understand who's right. Are the refiners correct, or I should say the manufacturers, 3M and DuPont, right, that this is not a dangerous chemical and it doesn't cause cancer, or does it, as the plaintiffs say? And there was a panel called the C8 panel, and they went off for a couple of years at the court's direction, and they came back with findings. And they concluded that there were several health issues involving PFOA, including 2 cancers. And so now you have towns who were drinking this for many, many years because they weren't testing for it. And now they're testing for it. And so obviously municipalities now are going to shoulder the cost if the manufacturers of these chemicals don't. That's an example. AFFF is kind of a sister chemical to PFOA. They're all PFASs. And so firefighting foam is a brand new litigation. It's there's cases all around the country brought by water providers that they have AFFF in their water supply and it's dangerous to serve it to people. And so therefore they have to shoulder the cost of doing that. And all those cases have been centralized in the District of South Carolina before Judge Gergel. And that case is ongoing, and it's relatively new, and you know it's too soon to report what's happening, what's going to go on there, but they are focusing on the groundwater contamination there. And again, it's a classic cost recovery action. Who's going to pay? Because you can't get rid of it. I mean, once it's in groundwater, you can't typically get rid of it. There are some remediation measures that can be done, but you really just need to get it out of the drinking water supply. Atrazine was a successful case that was prosecuted maybe, I don't know, I want to say it was a case that settled about 5 to 6 years ago. Same concept, Syngenta makes atrazine, and atrazine was used, I think, a lot for Christmas trees and some other other agricultural purposes. Excuse me. And it contaminated groundwater wherever it was used. It ended up in drinking water supplies, and atrazine is very dangerous to human health. And so before water providers could serve that water, they had to get rid of it, and that cost money. Water treatment is expensive. So the bottom one, again, these cases are still ongoing, but this is the most relevant actually to the issue of PAHs in sediment, because there's also litigation ongoing with PCBs in schools and in sediment in bays around the country. And so PCBs were used in caulk many years ago. And so PCBs are very dangerous to children. They're not good for adults either, but they're very, very dangerous to children. And so as caulk around windows and things degrades, the theory of the case is that those PCBs end up in the schools and they can harm children. And therefore schools want to get rid of the PCBs in the schools, and it's very expensive to get rid of PCBs. Same concept, who should pay? So I'm going to really blow through quickly so we have plenty of time here for questions. So this is the MTBE model, and I want to give you some information to show you the similarity between these cases and the issue of PAHs. So MTBE was added by the oil companies about 25 years ago. It was used from 1980 to 2006 to oxygenate fuel. And so the oil companies knew, 100% knew, that it was going to escape into the environment. They had, first of all, for years, they had been dealing with underground storage tanks that leaked. So they know when you store gasoline, it's going to leak. Everybody knew that, even though they were putting in new, the whole underground storage tank initiative was going on. That was a slow rollout. So as they were using MTBE and gasoline, they still had leaking underground storage tanks. And they had dozens and dozens and dozens of memos internally by their scientists saying, if we use MTBE as an oxygenate in gasoline, we will contaminate the nation's groundwater. They knew it was going to happen, but they were going to make a lot of money off of this. And MTBE, interestingly, like coal tar pitch, was a waste product of the petroleum industry. And so they have these stockpiles of MTBE, and they didn't want to use ethanol because they want to get rid of their stockpiles of MTBE, which was part of the reason, and there were others as well. Once it gets into the environment, it moves really fast through groundwater, much faster than BTEX, which tends to like soil. MTBE does not like soil. It loves water. It gets into the water and it moves fast. And it contaminated groundwater all across the country. And water providers virtually in every state were facing pretty intense costs to remove MTBE. Because gas stations are everywhere, even in bucolic areas, there's still going to be a gas station somewhere because people drive cars, and farmers use gasoline for farming. So really, there's no place that didn't have gasoline stations that had MTBE, except I should say for certain parts of the Midwest that used ethanol. Didn't go with the MTBE model, but most places around the country used MTBE. So same theory of liability, the cost of testing and treatment either has to be borne by the municipal water providers or by the petroleum companies. The petroleum companies knew, as I said, it would contaminate. And then there were all the major companies. There were actually about 48 defendants in this case. I ran this case, which is why I know it so well. Similar to PAHs, it's not going to go away. They're going to stay there until they're remediated. MTBE was less of a health issue. There were some health issues that were involved, but it made water somewhat unpotable. It imparted a bad taste and smell at very low levels. So there were about 150 something water providers, around 153 municipal water providers. In that case, they were all centralized in the Southern District of New York in Manhattan. And after about 8 years of litigation and a couple of trials, there was a settlement. And then after that settlement, we recognized, well, MTBE isn't going to go away, even though the oil companies had taken it out of the water supply. They knew that it was still moving through the groundwater. So there was going to be a second wave of municipal water providers after that settlement that ended up needing treatment. And that was the next settlement. There are cases that pop up every so often. There are still cases involving the state of Rhode Island. I think New Jersey is still going on. There's several state litigations that are still going on. In that case, there was some excellent theories of liability established that went all the way, many of these issues went all the way to the Supreme Court because the City of New York case went to trial. And only Exxon, all the defendants settled except for Exxon. And then Exxon appealed to the Second Circuit, in the Second Circuit Court of Appeals, which is where Manhattan Court is, the appellate court for the Southern District. The court affirmed all of these issues that are, in my opinion, very analogous to the coal tar and stormwater pond situation. And then Exxon filed a cert petition to the Supreme Court, which the Supreme Court denied. So this Second Circuit law is good law. And it's really an incredibly helpful tool for developing cost recovery actions generally. Then the state of New Hampshire went to trial again, once again, only ExxonMobil, everybody else settled. Not all water systems in the state were contaminated. They had both private wells and municipal wells, and they had a model for how to figure out damages. And then the jury awarded $800 million, of which they found ExxonMobil 28%. I wanted to end by saying a little bit about similarities between coal tar sealant and the MTBE. So both are products that are designed knowing that with waste products, and knowing that they can and probably will undoubtedly contaminate the environment. And when they contaminate the environment, everybody knows that at some point in time, if you're dealing with a chemical that's dangerous, you are going to have to do something as a city, as a state, to make sure in your parents' patriae capacity, if you're a state, if you're a city, in different ways, that you address those concerns. You know, one of the things about and this is my last point I'm going to make, the stormwater ponds, of course, they're not the same health issue that it is when it's in groundwater that you drink. Of course, if PAHs were ending up in drinking water supplies, we'd be having a very different discussion, because you can't wait on those. And stormwater ponds, there's a little bit more of a delay, because until you have to dredge those ponds, the sediment isn't going to hurt anything, right? It's not going to hurt anything sitting in there. But once it is removed, if it's not removed and disposed of in a hazardous waste facility where it won't escape into the environment again and potentially contaminate groundwater, it could cause widespread damage and danger to the community, which is why it's so important that these wastes go to a proper landfill, which is where the costs are that Randy talked about. So anyway, at that point, thank you. I'm sorry I can't talk about ongoing litigation, but I can't. So
Well,
thank you all.
That was great. Thank you very much, Robin. If we could, we'll give you a virtual hand clap there. I'd like to bring on our other panelists back onto the screen. And it's at this point where we're going to take some questions from the audience. And they're being collected here on a Google Doc behind me. So I'm going to read them out to the panelists. I have one here that's actually specifically directed for Robin, but others can also answer as well. So how can we push for a precautionary principle as a nation? Coal tar is not the only industry that, knowing the impacts of their product, are allowed to keep polluting and benefiting economically from it. Robin, you want to?
Wow. So what an interesting question to ask these days in particular. So, you know, we live in a country right now where the response to the pandemic is companies have been given a pass on pollution. It's just really extraordinary. Rather than thinking about what's the global reason we have all these problems, why are so many things happening that didn't used to happen? The answer is not to give all these companies a pass. But honestly, right now, I don't know. I don't know how to answer that question. Our country is not in a place right now with our current administration. And I'm talking about a national level. I'm not talking about states. I've thought about states in a minute. On a national level, we do not have an appetite for protecting the environment, for protecting human health. And we have an appetite only for helping corporations. And I think that is, for me, a very sad reality. But states have this incredible opportunity now to step up and say, you know, the heck with the federal government. I don't care. I don't have to follow their lead. I regardless of whether I'm a Republican, a Democrat, or something else, I do care about the health of our community, and I care about our environment. I care about the animals that depend on the environment, and there is zero leadership on the federal level. So we as a state have to do things that are proactive. And I think it would be pretty awesome for the states to get together and have their own little EPA, like, you know, a state-run EPA, that we say we're getting no leadership from the EPA. So let's have our own task force that actually sets up regulations that we all agree we're going to comply with. I mean, obviously not 50 states will go for it. I get that. I'm not that stupid. But I believe more would do it than we think if we did it smartly. But anyway, that's not necessarily answering the question, but that's my Pollyannic hope that would happen.
Very good. Thank you. I don't know, Randy or Matt, do you want to add anything to that question?
Well, I think one of it doesn't answer the question directly, but one of the most important concepts here is that of a statewide coal tar sealant ban. It's relatively simple to do. It required a good bit of research, review, discussion among regulatory authorities at the state level before the legislature adopted it. But once it's adopted, it has an enormous effect. Looking forward only, unfortunately, but still, that's huge. The idea that we only have 3 states in the country that have a statewide ban in place seems sad and unfortunate, and a situation that should be rectified.
Yeah, the idea of the precautionary principle, of course, is used over in Europe quite effectively, and we've chosen here in the United States not to do that. I often, when I talk to my students about the precautionary principle, basically the precautionary principle, for those who are not familiar with it, basically says prove something is safe before you start producing it. In the United States, we sort of operate under the paradigm of produce it, and if someone proves proves it's bad, then you have to stop. Now, both methods have their advantages. Obviously, the United States has made an incredible amount of money and created a lot of wealth doing it the way we've done it. The issue then becomes, okay, if we show that it's bad, how do we get rid of it, and who pays for it, right? The idea of reducing environmental regulation often comes hand in hand with tort reform, whereas if we've gotten rid of regulation, the only recourse we have is to sue. And so if you try and get rid of both of those, you not only you basically swing the pendulum all the way to the corporate side of let's make profits over pollution and any of the ill effects. We'll let somebody else worry about that. So I don't see the United States ever going to the precautionary principle, but that's why I think Randy's comment about the states is so important, especially when you have people who would be most adamantly opposed to the precautionary principle are often the same people who argue for states' rights. And so if a state wants to say that, look, we shouldn't do this, then they should have the right to do so. My opinion.
So I want to follow up on the precautionary principle issue, because what I've also seen is that there can be a tendency to replace chemicals that you know are bad, right? Because you've got lots of data to show all of their evils, potentially with chemicals that could be even worse because you know less about them. They're less well tested, but they're newer. And I mean, this has a tendency to happen in Europe, and I spent some time in Europe, so I've experienced it. I mean, I guess I want to ask, if we know that these coal tar sealants are bad, but they're serving some kind of function. That's why people buy them. If we want to get rid of them, what's the alternative? What do we replace them with that's less dangerous than they are?
I should take that on, if I may, which is, there's actually a pretty straightforward answer. It's asphalt-based sealant. Okay. So for instance, cities seal coat streets. You've seen where seal coat is put down and there's a thin layer of gravel put down over the street, and it takes a few weeks before all that, and it's really annoying. Yes. But cities do it everywhere. Cities use asphalt-based seal coat. That's also what the private applicators who used to do coal tar sealant in Minnesota are now using everywhere. The advantage is the difference in the concentrations of PAHs are 1,000 times less in asphalt-based seal coat than they are in coal tar-based sealant.
Yeah, it goes further than that too. The asphalt-based PAHs are more tightly bound to the material versus the coal tar. So the coal tar PAHs are actually more soluble. And so we did a study years ago for the Minnesota Department of Transportation looking at recycled road beds, right? So you go through and you chew up the road to put in a new road. What do you do with all that material? And MnDOT was concerned with using that as the base for another road, and they were worried specifically about PAHs leaching. And the only material that we found that was basically an issue for PAH leaching was the coal tar sealant based roads, which Minnesota had very few of. But it was dramatic, the increase in PAHs from the coal tar versus the asphalt.
Okay, all right, thank you. So let's switch gears a little bit and talk more in terms of the regulatory issues. Was there pushback from the industry when Minnesota passed their coal tar sealant ban? And if so, how exactly was that handled?
Oh my, yes, there certainly was. There's a trade council for the refiners, manufacturers, and applicators of coal tar sealant and other seal coat products. I'm not going to remember the name right now. I believe it's PTEC, Pavement Technologies. How the bans first started in Minnesota was that they were adopted at the local level. I mean, cities obviously are the ones that face these costs most directly. And a number of the cities responded more quickly than the state in terms of trying to enact bans. The Trade Council would come out to local city council meetings, usually enlist one or more small local applicator companies to participate and make the case, and they would make an impassioned argument before the city council. Almost invariably they lost, and a number, I think we had 29 cities in the state that had adopted local bans by the time the state considered it. The trade group also made their case before the PCA. PCA had the technical expertise to provide information for the legislature in considering the ban. I remember we had a full day-long meeting with the commissioner and other senior managers from the PCA sitting in for the entire day, where researchers from USGS, the researcher Dr. Judy Crane from the PCA spoke, but then the Trade Council for the Seal Code folks also had a chance to speak, and they brought scientists of their own. At the end of that day, the commissioner basically said, we're going to go ahead and make a recommendation for a ban to the state legislature. For these sorts of things, there is always pushback. Mm-hmm. And in this case, it was well organized and it was well organized. It was not terribly effective because they didn't carry the day.
Okay, I've got a related question here on the regulatory side, and that's regarding so the need, the requirement to remove PAHs from the ponds, is this a federal or a state requirement? I think it's federal. But.
No, I believe what we have on the stormwater side is the stormwater permitting is rooted in the Clean Water Act at the federal level, but the permitting authority is delegated to the state. So it's the Minnesota Pollution Control Agency that writes the MS4 stormwater permits. And those permits, we've been told by the state agency to expect a 3-stage process where cities would assess their ponds, and then where they found that enough of the water quality function was lost, they would need to dredge the ponds. That process, that 3-stage process, is now effectively on hold because all of us have made so little progress in trying to find a cost-effective solution to this problem. And the PAHs are they're stable and safe when they're in the bottom of these ponds. It's only when they're dredged. Looking at the dredged material is another regulatory environment. Soil reference values come in, and cities are required to test the sediments, compare the concentrations and the chemical mix of PAHs to these soil reference values. And depending on where they fall along a 3 threshold spectrum, that affects how the dredged material needs to be disposed of.
Okay, yeah, thank you. So I have a couple here from the audience that are probably directed to Robin mostly. So are petroleum companies lobbying for legal or regulatory changes to make future cost recovery actions harder to pursue? And if so, do they have political backing?
So in the middle of the MTBE litigation, they lobbied hard, and we won by 1 vote. It would have had a it would have immunized the oil companies for their MTBE contamination, because it's interesting, their arguments. So the Clean Air Act of 1990 required that they oxygenate fuel, and there were, I think, 4 or 6 options for oxygenate. And when EPA issued its regulations, it had MTBE as one of the options. So that complicated, needless to say, the legal theory. Well, if it was one of the options, how could we possibly be responsible? And so they moved for immunity in the Congress. And of course, if they had been granted that immunity, our case would have gone away overnight. So the answer is they tried and they failed. And they always try. I mean, you know, I'm working on Roundup right now. That's my, been 5 years working against Monsanto in Roundup. And they try all the time to have various legislative fixes to liability. I mean, companies they have access. They have much more access than any of us on this phone do. Well, I don't know. I mean, I don't know everyone who's on the phone, but certainly more access than most of us, because the regulatory agencies, in large measure, at least on the federal level, their interaction is much more with the companies than with us, because they're the ones that are going to the EPA or FDA if it's a drug, or the USDA if it's various pesticides, which is also EPA, by the way, to say, can I do this? And can I do it in this manner? And then they have relationships. Some of the documents in Roundup were shocking between the federal government and Monsanto. I mean, shocking. I was amazed when we got those in discovery. Less so in the MTBE case. There were not that many between the feds and the petroleum companies. I was surprised. Either they just never gave them to us or they didn't exist. I don't know.
So on a related theme, you, I'm sure have experienced this, but how do you deal with it when the industry denies well-known facts? So one of the audience members is referring to experiencing a consultant working for the coal tar industry denying that PAHs were carcinogenic. How do you deal with that?
We call Matt and say, Matt, will you come testify, please? And can you please tell the jury and the judge and everybody? I mean, you know, all these cases, all of them have a battle of the experts. No question about it. At the beginning of all litigations, there's a battle of the experts. So in MTBE, the main battle of the experts was about whether MTBE can be tasted and smelled at the levels at which it was found in drinking water, which was usually anywhere between 1 part per billion and 5 parts per billion. There weren't that many municipalities that had them in the 30, 40, 50 parts per billion. And so that was the big battle. In Roundup, it's, can glyphosate, the active ingredient, cause non-Hodgkin's lymphoma? They're still fighting that, even though we won in the federal court and we've won 3 trials. They're still fighting it, and they're still saying that the science isn't there. They're never going to agree. They're probably always going to say PAHs aren't going to hurt anybody. They'll never come out and agree to that, regardless of the science.
Well, and I mean, as a scientist, I find this fascinating because this stuff can get pretty technical, and there can be legitimate disagreements among honest scientists that, you know, that are just legitimate. But I mean, I've also seen cases where people can use the uncertainties around the science to sort of undermine the evidence, which I think is kind of what you're referring to, which is a little unfortunate.
Mm-hmm.
I was present at some city council meetings where these kinds of discussions took place, and these sorts of assertions were made by the Seal Code technical industry group. What happened in those cases was that there was a representative, a staff person from the Pollution Control Agency who had come to the meeting. PCA has done some excellent research in this area, and the staff person was able to convey the results and information from that research to the council in a concise, accessible sort of way. And in almost every case, it carried the day.
Thank you. Thank you. I'm looking at my little clock here, and it's 1 o'clock. And that was a fast hour, I'm afraid. And to be respectful of everyone's time, I'm afraid I'm going to have to end this fascinating conversation here. We've still got questions pouring in. So I want to thank you all for a really fascinating discussion. And I want to thank all of our audience for joining in this afternoon. I hope you enjoyed the discussion. And remember, freshwater needs your support. And I want to thank the freshwater staff for their excellent technical support. It all held up. We made it. Thank you, everybody. Enjoy the rest of your day. Hope to see you all in person soon.
Thank you so much.
Thank you. Bye-bye.